Get ready? Start. While considering the rival submissions, it is necessary to bear in mind that compassionate appointment is an exception to the general rule that appointment to any public post in the service of the state has to be made on the basis of principles which accord with Articles 14 and 16 of the Constitution. Stop. The dependents of a deceased employee of the state are made eligible by virtue of the policy on compassionate appointment. Stop. The basis of the policy is that it recognizes that a family of a deceased employee may be placed in a position of financial hardship upon the untimely death of the employee while in service. Stop. It is the immediacy of the need which furnishes the basis for the state to allow the benefit of compassionate appointment. Stop. Where the authority finds that the financial and other circumstances of the family are such that in the absence of immediate assistance, it would be reduced to being indigent, an application from a dependent member of the family could be considered. Stop. The terms on which such applications would be considered are subject to the policy which is framed by the state and must fulfill the terms of the policy. Stop. In that sense, it is a well settled principle that there is no right to compassionate appointment, but where there is a policy, a dependent member of the family of a deceased employee is entitled to apply for compassionate appointment and seek consideration of the application in accordance with the terms and conditions. Stop para. In view of the clear terms of the policy, we are of the view that the High Court was in error in issuing a mandamus to the government to disregard its policy. Stop. Such direction could not have been issued by the High Court. Stop. The High Court has drawn sustenance in issuing mandamus in the above terms on a decision of this court in Govinda Verma (Supra). Stop. That was a case of compassionate appointment where, in the course of the proceedings before the High Court, a learned single judge had directed the Life Insurance Corporation, which was the employer of the deceased employee, to make an inquiry and submit a report whether the members of the family engaged in gainful employment were also supporting the family of the deceased employee. Stop. This court, in an appeal against the judgment of the High Court rejecting the petition for compassionate appointment, observed that the officer who had inquired into the matter in pursuance of the order of the learned single judge completely omitted to furnish any report on the points which were required by the High Court to be investigated. Stop. The High Court rejected the petition on the ground that the family was in receipt of family pension and other amounts towards terminal benefits. Stop. Reversing the view of the High Court, a two-judge bench of this court held that it was wholly irrelevant for the departmental authorities and the learned single judge to take into consideration the amount which was being paid as family pension to the widow of the deceased. Stop.